keeps me from my winter hell. I've got candles and candy, I can be your daddy if you only let me creep into your prison cell. Hey baby, can you tell I'm not a criminal? Your choice is seminal. I want you to stay true to what's right for you. No matter who or know what will others say, just find your way and try to stay true. Speak low, stand in your row, try not to show this life's a show. Try not to glow. Way down below, oh, it's a lot of woe. And that's not a place where you would like to go. I've got cigarettes and brandy, which could come in handy if you just help me loosen up my hand grenades fuse. Baby, don't refuse my truth, but it's up to you now to choose. I want you to stay true to what's right for you. No matter who or know what will others say, just find your way and try to stay true. I want you to stay true to what's right for you. No matter who or know what will others say, just find your way and try to stay true, 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 true,
Hi, you guys. How are you? I've missed you all. Let me say hello to everyone. Hello, Ginger Snaps. Thank you so much. I appreciate that. Hey, Mrs. Troy. Okay, I need to apologize to you. I know I did some confusing things, particularly Mrs. Troy was very like, where's Bindi? Where's Jen Lu? Respective to the Stephen Stern situation. And I'll address that in just a second. But let me say hi to everybody. So I'm sorry I confused you, Mrs. Troy. Hey, Sarah Bellum, good to see you. Hey, Sissy's mom, Clicker AK, what up? Kelly, Neat Noodle, Lil D, Pointer Lover, hey. Hey, y'all, hey. Hey, poor Linda, good to see you. Hey, proud grandma of two, good to see you guys. Hey, Shambles, what up? Hey, Coffee and Skeletons, good to see all of you guys. Thank you all so very much for being here. All right, so let me tell you what happened with the Stephen Stearns thing. Okay. Hey, KD, good to see you. I'm sorry I confused you guys. I'm so sorry. Let me tell you what had happened, okay? I'd been at my daughter's house all day, and me, my daughter, and the little Chicky Nugget Pot Pie Esquire were hanging out, and I was working at her. I was helping my daughter clean, okay, because that's what I do. All right. I just like to do it. I like to organize. It wasn't really cleaning. It was more organizing. And I'm good at it. I don't want to toot my own horn, but toot, toot, I am good at organizing. So we were doing that. And I came home and I was like, okay, I'm going to go. I made that post and I was like, all right, I'm going to go live. Then I was like, well, there's this was like 4 o'clock. I was like, well, I have some time. I'm just going to chill out, maybe rest my eyes a little bit. Well, then 4.5 hours later, I was like, OMG, I woke up. I guess I was just super tired. So then, hold on just a second. I want to make sure I don't miss this. So then what happened was, then I was like, oh my God. And then I got like the notifications, and people were like looking for me. And then I felt, oh my God, I feel awful. So I made the post, and I intended to go live the next morning. I do have the video. I screen recorded it. I adjusted the audio because, quite honestly, it sounded like whoever was in charge of the audio, like I said before, recorded it with a tin can and a piece of string. Seriously, it was terrible. So I fixed it. But while I was fixing it, of course, I was listening to it. So I was listening to it, and I found it to be, sort of one of those situations where, yeah, it needed to happen, but the important things, I think, for me anyway, what I thought was important didn't come until the very end, and it was really quick. So we'll just talk about that now while we have time, while we're waiting for the court to go live. I've got it pulled up. We're not going to miss anything. Don't y'all worry. Okay? All right. The important thing I thought at the end was, like, let's just start with what he wanted if you missed it. He wanted the defense wants no newspapers, like newspaper stands in the, hold on a minute. Let me turn my silent mode on. Sorry about that. Newspaper in the lobby of the courtroom. Okay. Then they wanted him not to be in restraints, but basically at the end of the day, the judge was like, look, he's got to be restrained in some kind of way. So they settled on a leg brace. Okay. Then there was a situation with the pen. Apparently the inmates, when they are awaiting trial, are only allowed to have this flex pen thing. Flex pen, bendy pen, whatever you want to call it. Anywho's, it's not reliable. It runs out of ink. You got to do a lot of things. And his defense attorney said it would be disruptive to the process. So the judge said, okay, fine, whatever. He can use a felt tip pen, but he must leave it in the courtroom. Anytime he exits the courtroom, we'll be checking, yada, yada, yada. Okay. So there was that. Then they get to the end of the hearing, and the state says, wait a minute, we need to discuss something just briefly, logistically. All right. Hey, Deets. Oh, my goodness. Good to see you. All of you guys, thank you so much for being here. I appreciate it. Please, make sure you give your girl a thumbs up. All right. So at the end, they're talking logistics, and the logistics were what was interesting to me, because we've talked about this. How are they going to show the material that they downloaded from the phone, which, by the way, if you missed it, the phone comes in. Hugely important. Huge win for the state, huge loss for the defense. Okay. So, the phone is coming in, and they're talking about how they're going to display this material, and actually whether or not they feel like they should close the courtroom. Well, the state's like, Your Honor, we appreciate that, but I don't think that we legally can close the courtroom for that, because there's no surviving victim, which I thought was quite interesting. And because Florida they mention it all. They are the Bethany Frankel of the justice system. They will mention it all. Okay. So I was curious about that. And they were talking about a whiteboard. And then they were talking about, because there's videos as well, and they have sound, which it's heartbreaking. Okay. And like I've said before, what Stephen Stearns did to Maddie for all of those years, he objectified her, he dehumanized her, and now it's going to be shown in open court. Well, obviously, it won't be streamed that way, like the camera will pan, but I don't know how they're going to do the audio. If they're going to mute, I don't know when it's playing. I don't know how because they didn't talk about that, but it's just awful. And it made me, I'm not going to lie, I did question, should I even be streaming this trial? Ethically, should I stream this trial? And I've been thinking about that all week long. Should I stream this trial? And you guys tell me what you think, but my thoughts are this. I think that I am capable of being sensitive enough and doing it in an ethical way. I also feel like Maddie, her voice was taken from her. Stephen Stearns took her voice at every opportunity. And now he has taken her voice, and it's final. I think that if Maddie had to endure it, we should sit through it and listen to what she endured. Perhaps there is something that we can learn from this and prevent it from happening to another child, even if it's just one. Perhaps something will resonate with somebody watching it, and they'll see a red flag in their own life and be like, "Oh my God," and it will stop. I think that the other thing is, I think that what happened with Maddie is the result, in my opinion, from the way that the evidence is starting to stack up, is the result of grooming, years and years of grooming. And I think that it is important for us to understand what grooming looks like. Again, so that we can potentially prevent it from happening to another child. So I will be streaming the trial. We're going to watch it together. We're going to get through it together. Okay? That's the choice that I made. Let me show you what's going on over here in the Idahos. Court will begin soon. It hasn't started yet. I just wanted you guys to know that we're not missing anything. So I'm going to stream it. We're just going to get through it together. That's all I can say. So what's going to happen today, apparently, is basically it is a hearing to lift the non-dissemination order. What do I think is going to happen today? Well, I think that the state, I don't think it's going to get lifted. That's what I think. Okay. I think that the judge is going to hear from the media. I think the judge is going to hear from the people who want the non-dissemination order lifted. But I think ultimately what's going to happen is it's not going to be lifted. This is what I think is going to happen. I think that the judge is going to rule that the non-dissemination order stay in effect until after sentencing. And I think that's what's going to happen. I think that the judge is going to want Bryan Kohberger to make it to the sentencing phase of all of this. And I think that's just what I think. That doesn't mean that's what's going to happen. That doesn't mean it might be like a mix, right? Like he might say, well, these people, the non-dissemination order can be lifted from, these people it can't. I don't know. I don't know what's going to happen really, obviously. I mean, I'm not, I can't. I'm gonna to quote our friend Kai, the hatchet wielding hitchhiker. I can't call it. I can't. I really don't. Now I will say, oh, really, flutes. All right, we're in.
All right, we are on the record in State v. Kohberger, CR 0124-31665. Present today by video is the defendant in custody with counsel, Ms. Taylor, Ms. Barlow, and Ms. Massoth. State is represented by Mr. Thompson, Mr. Hurwitz, and Ms. Jennings. On behalf of the media petitioners, we have Ms. Olson and Mr. Pedersen. Today's hearing is to discuss the media's request to terminate the non-dissemination order. The state filed a response indicating it was no longer objecting to that, and the defense did file an objection indicating that they do have a continued objection to lifting the non-dissemination order. I've read the briefs that have been provided by the parties, and I'm going to attempt to shortcut things here a little bit by asking whether the defense, who is the objecting party, has anything additional to add beyond what it had in its briefing before. I don't know that I need to hear from, frankly, the petitioner. I think the briefing was adequate, so let me just start with Ms. Taylor to see if there's anything else she wants to add.
Your Honor, there is not, but if there's further argument, Ms. Barlow will be making that argument on behalf of the defense.
All right. And to be fair, Ms. Wilson, was there anything you felt was important to add that was not contained within your briefing?
Your Honor, we would just briefly say in response to the defendant's brief, we certainly understand the expressed concern about the media coverage of their client. We don't think continuing the non-dissemination order helps that at all. It simply continues to limit the ability of the members of the press to reach out to the people who know the most about the case. It doesn't obligate them to say anything. We also understand that they expressed that there was a due process right related to the sentencing. I read the case that they submitted. I think that there is obviously a due process right at sentencing, but I don't think that case is really it doesn't provide any guidance to the court here, because that was about information provided to the court, and given the very limited scope, and we understand it's very important, but given the very limited scope of what's to be decided at the sentencing, we don't think the arguments that Mr. Kohberger made should outweigh at this stage the First Amendment rights of our clients. Thank you, Your Honor.
Thank you. All right, in light of that response by the media outlets or interested outlets, Ms. Barlow, do you want to add anything?
I would only say, Your Honor, as this court is well aware, the publicity in this case is so extensive and emotions are already so high that adding fuel to the fire of media interviews or a rush to interview people as they leave the courthouse or enter the courthouse would only increase the concerns that the defense has. And even though the plea has a specific sentence attached to it, as this court is well aware, things happen in plea hearings and, sentencing hearings. And to minimize the possibility of that, we request that this order stay in place.
All right, thank you. All right, as the court has considered the petition, frankly, the court was prepared at the time the plea was entered to lift the non-dissemination order in order to give the parties time to evaluate that and to ensure I wasn't missing anything. When both sides objected, I agreed to continue the non-dissemination order. I also indicated that I would have the potential to look at that again before sentencing, because frankly, I anticipated the motion from somebody, in this case, the Ms. Olson and her clients, was likely to be coming. And At this point, I do not believe the purpose of the non-dissemination order, the primary purpose, which is to ensure that we can seat a impartial jury, is any longer at play. The concerns identified by the defendant, while certainly not to minimize those, they are concerns and they are significant concerns. I do not think, however, the non-dissemination order and the right of the public to information is outweighed or outweighs those rights, I should say. And frankly, I don't think that lifting the non-dissemination order will meaningfully impact those concerns. I mean, the media frenzy, as it has been described, will continue regardless. It is a little bit like water will find low ground. In this case, the media is going to write about something regardless about this case. The lifting the non-dissemination order does not require the counsel or others who were previously bound by it to speak, and the state has indicated that they don't intend to until after the sentencing. And certainly I would hope that the media interests would respect those positions and give people the space that they need
I think so,
and
Deets.
request. In terms of,
I forgot
for
he wanted
example,
to lift it
defendant's
before.
family and others coming and going at the sentencing, we intend to have, as we did before, appropriate security measures in place to ensure that they, as well as the victims, are allowed to get in and out unscathed by the media, if that's what they wish to do, or if they wish to speak to the media, they can do that as well. At this point, I just don't think that I can justify the continuation of the non-dissemination order. I think the rights of the public to information in this case is paramount, given the fact that a plea has been entered in this case, and so I'm going to lift the non-dissemination order. But I want to point out what that means and what it doesn't mean. So obviously nobody's required to speak to the media, first of all. Second of all, I want to be clear that the court's prior preservation order to the parties is not lifted and continues to stay in place. And so it's important to understand that those obligations still exist.
He's still looking into what had
And then,
happened.
the other thing I want to point out is that by lifting the non-dissemination order, that does not convert sealed documents to unsealed documents. Documents previously sealed by the court are still sealed. Now, I see the media also filed a petition to be heard to unseal everything. I'm denying that outright, the request to intervene, because I think it's premature at this point. So the court will its intent is to,
I know what that means.
after sentencing, begin the process of
we
reviewing
go.
all the sealed material in this case to determine what should be unsealed and what should not be unsealed.
No,
That
sissy's mom.
process will include an opportunity for counsel to register any objections to unsealing documents, specific documents, and request to redact certain sealed documents before they are unsealed, or unseal them in a redacted form. I intend to do that in groupings of documents at a time. As I sit here now, my thought is I'm going to start from newest to oldest, because those are the ones that I have the most working knowledge of as to the reason for the sealing of the documents, as well as
tartar sauce.
the
We're going to
content
get
of
it
those documents.
backwards.
So I think I can get through those more quickly. As we move backward in time, it's going to take further or more extensive review by the court to figure out to
Okay,
obviously
so
review the content of those documents, listen to those hearings, et cetera, and determine why they were sealed and whether that rationale still is necessary, or that rationale still requires the documents to maintain that sealed status. And so before everybody gets out their pen and paper and sends in public records requests, understand those will be denied for sealed records until they are unsealed. And that process is going to take time. And I'm not talking days, I'm probably not talking weeks for that to be accomplished. So I hope people understand patience will be required to get through that, as I'm going to have to review those myself to make those decisions. Now, we may be able to speed things up if neither party objects to groupings of documents or specific documents being unsealed. But it's important to review those because those documents may include information that, pursuant to Rule 32, are not to be made public, including birth dates, social securities, information about minors and victims, and information that would be
yes, Violet. Yes.
essentially
The preservation orders. Yes.
inappropriate to unseal, including protection of individuals from undue harassment, et cetera. And so that's just going to take time. In addition, I'm unlikely to unseal much until after sentencing and after the appeals period has run. Now, I recognize the plea agreement includes a waiver of the right to appeal, but as the parties probably know, the U.S. Supreme Court in Garza versus Idaho has indicated the fact that a defendant waives the right to appeal doesn't mean they don't have the right to appeal. And so it may affect the outcome of that appeal, and it may affect the underlying case and the plea agreement, but nonetheless, the right to appeal does not go away because of the waiver. And so I think it's important for that time period to also
It's
play
a little
itself out,
different in
to see that
Idaho.
it,
We'll talk
goes
about
the
all
way that I
this
think,
when we're
people
done, when
intend
it's done.
and expect it to. And so I will be entering an order in the next week or so outlining the process for the review of the sealed records. And counsel will need to maintain a presence in the case in order to review those materials as they are proposed to be unsealed by the court. Because the timeline that I will likely give you will not be, I suspect, extensive as for each group of records. So I might give you 14 days, for example, to provide a response as to a group of, a dozen or a couple dozen records at a time. So just sort of heads up and fair play with respect to that. Any questions by the parties about the ruling today?
Not from the state, Your Honor. Thank you.
No questions from the defense. Thank you.
Ms. Olson, do you have any questions?
And I don't, Your Honor. I wasn't certain if I was included within the parties. I would just say I think that the court's proposed manner of moving forward on the sealed records will likely largely address our interests. So we appreciate the court setting that out in this hearing today.
Yeah. If certain records after review maintain their sealed status, it would be at that point that I would entertain requests for me to consider that more formally and to have a voice in that. But I think until I've gone through that process, it's premature, which is why I don't intend to take up your motion, your more recent filed motion at this time. So,
Thank you, Your Honor. We appreciate that.
all right. And with that, then we are adjourned. Thank you.
Okay, so a couple of things. One, he wanted to make it very, very clear that lifting the non-dissemination order has no effect, no impact, and doesn't change nothing about the preservation order. He is still looking into what happened with Dateline. because in that time, at that time, the non-dissemination order was fully in effect. Okay, so that investigation apparently is still ongoing. Now, with the unsealing of documents, what I took from that is basically we're going to have, and I'm using this as an example because this is the most, this is an example that most people are familiar with. What we're going to have, I believe, is a situation similar to the Watts, okay, where the parties all sit down and they go through, first of all, they're going to go through it backwards. So the records that, or the things that were sealed first are going to be reviewed last. He's going to start with the documents that were sealed the most recently and work backwards in time, because obviously he came in as after Judge, right? So he's familiar with the more recent ones. He's less familiar with the older ones. So they're going to sit down and do that. Okay. Which is something that they also did in the Watts case. Now, Chris Watts had some requests of things that he wanted sealed, and they stayed sealed. Okay. So I do think that what's going to happen here is, I think that, first of all, I'm kind of bummed because I'm going to have to go back and look and see about what was sealed the most recent, the things that were sealed most recently. I am, however, pleased that he, and I'll say this too, with respect to the unsealing of things and keeping things sealed. They're going to go through and they're going to talk about what's quote unquote in the public's best interest. But there's going to be things that are going to be redacted, and like birth dates, phone numbers, things like that nobody's going to argue about, even the media. We don't, so some of the process will go a little faster. Obviously, I think that if they were to unseal some of the police reports, the police notes respective to the crime scene, I think that might be enough detail that we can, as the public, can understand what happened in that house we don't need the autopsy reports. Okay. We're not going to get them, and we're not going to get the pictures either. And I don't know that anybody necessarily wants to see them. But I think that the crime scene notes, I think we'll have enough there. Okay. Sleuths Investigate says, dumb question. No question is dumb. But could the motion and filed on the alternate suspects be one that gets released? I think if it gets released, I think it gets released in part. And here's why. It depends on what's in there. If there are names of alternate suspects, those are likely going to be redacted. So if we get it, if it gets released, it's only going to get released partially. I don't think, besides, because, I mean, to be fair, we don't need those names. And I'm going to tell you why. I don't know how many of you guys in chat have had the opportunity, and I'm kind of waiting. I need to put up a poll. I'll do that after this live. I'm waiting to discuss the docuseries from Prime, okay? Because I want to make sure that everybody has had an opportunity to watch it and think about it, and then we can have a discussion, myself included. Sometimes I have to watch things a couple of times because I always miss stuff, okay? But I have watched all 4 parts, and I don't think that there were I think there were people who, when they were covering this case, I don't think that they appreciated what they were doing in terms of covering this case when they were pointing fingers at Hunter J specifically and others. Okay. I don't think that they could appreciate what that does to a person, how that makes them feel, given the fact that Hunter is the one that actually saw Xana and Ethan. Can you imagine being that kid's age? Now think back. I'm not talking about thinking about how you'd feel today. All right. I'm talking about think back to how you would have been at his age, because at his age, there's a difference, right? He's very, very young. Learning how to compartmentalize and deal with trauma and traumatic events, that comes with age and experience. Okay. This was probably the single most traumatic, messed up thing that at that point in time had ever happened to that kid. And I hope that it stays that way. I hope that he never has to go through anything anywhere near as close as that. Okay. But as horrible as that. So given what has happened in the past, if you are one of those people that might be on that list of alternate suspects, would you want your name out there? So I think if it does get released, I do think it's going to be redacted, and I think it should be. I think that those people deserve that. It was, the fact that she was even introducing alternate suspects, and then her client's like, yo, I want to take a plea deal. I mean, okay. Like, I don't know what the point of that was. Now, the time period in which it's going to take. Okay. So the judge cited the appeals. Okay. This is kind of confusing for people because Idaho does things a little bit differently. All states do things a little bit differently, but let's talk about what waiving your right to appeal means. Okay. In Idaho, when Kohberger took this plea deal, okay, and let me say this, the plea deal has not been accepted yet. It's not done until the judge signs off on it. That happens at sentencing. Well, I guess it is done at this point. So it's done. But sentencing needs to happen now. Okay, so the plea deal is over. But when you waive your right to appeals in Idaho, it means something a little bit different. It doesn't mean that you waive all your rights to all appeals in perpetuity, like you would think. That's what it sounds like in plain language. And that is because of a case called Garza versus Idaho. Hold on a minute. So basically, this case is about the presumption of prejudice for Sixth Amendment purposes applies regardless of whether a defendant has waived the right to the appeal. In 2015, petitioner Gilberto Garza Jr. signed 2 plea agreements which required him to waive his right to appeal. After sentencing, Garza informed his trial counsel of his wish to appeal. Due to the appeal waivers signed by Garza, counsel declined to file a notice of appeal. After the time period to file an appeal lapsed, Garza filed a petition for state post-conviction release on the basis of ineffective assistance of counsel. The trial court denied relief and the Idaho Court of Appeals affirmed. The Idaho Supreme Court affirmed, concluding the presumption of prejudice as recognized by Roe versus Flores Ortega does not apply when the defendant has agreed to waive the right to appeal. So the waiving of the right to appeal is not, like I said, definite and in perpetuity. Okay. So Bryan still has, now are his appeals limited? Yes, they're limited. What he can actually appeal is limited. And I'm not an attorney. And while I somewhat understand what he can and cannot appeal, I am not very comfortable like talking about it because I kind of understand it, but again, I'm not an attorney. And so I don't feel comfortable explaining it that in a way without being an attorney, without that education. I just don't feel like that's a good idea. I think depending on, let's say Bryan decides to appeal. The thing about appeals is this. During the appeals process, the burden shifts solely to the appellate. This is why appeals take a very, very long time. This is why, and frankly, they're not successful, because the thought process really is that during the trial, that's the time when these types of things should be addressed, and that the defendant, because during the pretrial and the trial, his or her, the defendant's rights are supposed to be, paramount to everything else going on in that courtroom. The thought is, and this isn't a correct thought, but this is just what the thought is. The thought is that the trial judge is paying attention to all of that and likely didn't err. Okay, we know that happens. Judges are human beings, and anytime you have any situation where human beings are involved, there's errors. It's just the way that it goes. But it would depend on what it is that he is trying to appeal, the likelihood of success. Typically, when you've taken a plea deal like Bryan Kohberger has, it's even more difficult for the appeals to be successful. And quite frankly, I don't think that Bryan Kohberger would ever have based on what I've seen so far, obviously that's subject to change. Hold on a second. I need a little sip. Pardon me. Basically, I feel like an ineffective assistance of counsel, based upon what I've seen from Ann Taylor. She advocated a lot for her client. She advocated well. I don't think he has a snowball's chance in hell of mounting a successful ineffective assistance of counsel claim. First of all, at the end of all the things that were Bryan Kohberger was being asked, he was asked about how he felt about his counsel. Okay. And did she do a good job? Blah, blah. Did they do a good job? Yada, yada, whatever, right? Okay. He answered in the affirmative that he was satisfied with his representation. That right there makes it difficult. Okay. And I can give you some really good examples of ineffective assistance of counsel where you would really think that they had a great shot and a strong shot at appeal, and they don't. It gets shut down. So Kiki wants to do a quick reminder of the dateline issues. There's been so many turns in this case, I've lost that memory. So after the dateline episode came out, and they used a lot of language like a source close to the investigation, Ann Taylor filed a motion with the court, and she was like, wait, back the milk truck up. What source close to the investigation? We're not supposed to be talking, none of us. There's a non-dissemination order. How in the actual F does Dateline have information? And they did have information that none of us had heard before, and that is facts, okay? I watched it and my mouth fell open a few times, Okay, like, whoa, I didn't know that. Whoa, I didn't know that. So at the end of the day, the judge said, all right, here's what we're going to do. I'm going to draft a preservation order, which means none of y'all, whether you work currently with the defense, whether you work currently with the state, whether you worked previously with the defense, whether you worked previously with the state, don't delete anything. Don't destroy anything. Don't delete anything. Don't all of a sudden, put your phone in the microwave accidentally on purpose, and none of that. That's what it is. They're looking into it. They want to know, the judge wants to know who violated his order. That's it. That's all. What comes from that, once, if anything is discovered, right? Whatever, I don't know what consequences a person could face. I guess it would depend on who did it and what was leaked and all the things. So, it is what it is. We'll just have to wait and see. But that is what's going on. So, next week, the 23rd, your girl will be streaming Kohberger's sentencing. Also, on the 22nd of July, that is when Stephen Stern's trial is scheduled to start. However, when they talk about the trial starting, the trial starts with jury selection. Obviously, we would not be privy to that. They don't. Typically, they don't stream jury selection. I don't want to say never, because there have been circumstances where we've been privy to some audio from jury selection, but by and large, they don't usually stream jury selection. It's happened before, but it is what it is. That doesn't mean I try not to speak in absolutes, because sure as you do that, here comes out, how they say 99.9% of the time. What about the 1%? Yeah. When you speak in absolutes, that 1% or 0.1% comes and bites you directly in the keister. And ain't nobody got time for that kind of negativity. So usually, pretty much what will happen, this is what I think. I think that jury selection is probably going to take a couple of days, which means that I do think that there's not going to be any type of conflict between the Kohberger sentencing and the beginning of Stephen Stern's trial. However, if I'm wrong about that, this is what will happen, okay? Stearns is in Florida, which is 3 hours ahead of Idaho time. So likely when Kohberger's sentencing is getting underway, Stearns will be at lunch. So we might do Stearns in two parts: morning, cover the Kohberger sentencing, come back to once the sentencing is over, then we'll resume covering or watching the Stearns trial. I think that's like the best. That's the best solution. Brandy, his trial starts with jury selection on the 22nd of July. I don't know. I think it's going to take at least a couple of days. And so I don't see it starting until like maybe Thursday, Friday. Well, Sluice Investigate says, since the gag is lifted in the Kohberger case, does this mean anyone that was under the gag order can now seek legal action if they chose to? They could have sought legal action at any time. Okay. You are allowed to talk to your attorney always, but it has to be your attorney. Like, you've got to retain the attorney, which then would put that attorney probably under the non-dissemination order as well. But it's been lifted. So the judge would never not allow people to not speak, to an attorney. You always have the right to an attorney. So I think that they could do it always. It's just that they wouldn't have been able to ever talk. They wouldn't be able to talk about it during the non-dissemination order. So, oh yeah, Elizabeth, this is not going to be a quick process. Elizabeth says there is still tons of classified or sealed evidence. Yeah, this is not going to be a process. I saw that too. Sissy's mom says, how about our girl Sarah Boone being quote unquote ghosted by her appellate attorney? Looky here, Boone. You have not been ghosted, obviously, because your appellate attorney has filed to get a continuance, an extension. So you're not been ghosted. Just because your attorney does not want to speak to you on the phone all day, every day, or even an hour every day, or even an hour or two once a week. I mean, bruh, have you met you? Have you ever listened to yourself speak, Sarah Boone? Even Job would lose his patience with you. So, nobody's ghosting you, Sarah. It's just that you idle at difficult, okay? That's like your default. Difficult is your default setting. And it never gets better. It only gets worse. That's all that it is. All right? Nobody's ghosting you. Appeals take years, all right? And what if your appellate attorney started the process? He asked for the transcript. What if the attorney goes through that transcript with a fine-tooth comb and finds no errors? No errors that are significant enough to base an appeal on. You see, there's that problem too, Boone, but you don't think about that, do you? No. All right, so that's my answer to Boone. All right, so there you have it. That's the schedule. Also, for those of you who are waiting patiently, which I appreciate, I do have calls that I need to upload and put out. So first I'm going to put them out with no commentary, but the commentary portion will be the memes and the GIFs. Don't y'all worry. Those are staying. Okay. I will take care of that. Today is what? Thursday? Let's do it for Friday. I'll make sure that those get uploaded and premiered on Friday. Then I need to check with my girl Allie, see when it would be a good time for her to do commentary over them. So we'll do that maybe Saturday. I got to talk to Allie. So there you go. That's really all that I had for you guys today. I appreciate everybody being here. We will be back covering trials next week. And just so you guys know, the reason I'm not going live and doing all the things as often is because I know that the Stephen Stearns trial is going to start next week. And that means that I'm going to be at the computer all day. So I've been going to the pool and hanging out with my little Chicky Nuggy Pot Pie Esquire as much as I can, because she told me the other day, she's so cute. She said, Granny, I don't want you to leave. I miss you when you're gone. Now, how can you can't leave when your little granddaughter says that to you? You can't. So you got to make sure that you spend all the time that you can with that little Chicky Nuggy, because you know that you have to work, right? You got to cover these trials. And I want to watch this trial. And obviously, no trial would be ever anything that I would ever want her to see, obviously, right? But, I need to spend as much time as I can, because I'm going to be spending a significant time away. And usually when the day is done, right, with the trial, that's right about the time that it's going to be time for dinner. It's going to be time for bath or shower and, Mimi's. So that's not very many hours. So there you go. I've been swimming and laying out and all that stuff. I've gotten quite a nice little tan. I'm actually kind of proud of myself, but I'm not tanning my face, because as you know, tanning your face causes wrinkles, and I don't want that either. All right. It's not worth it to me, even though the salsa in me makes me I forgot how how much I like it when I tan, like how I look, but I'm not doing it on my face because time is just dragging me through. Like I'm getting older and there ain't nothing I can do about it, but I ain't got to look old. So there you guys go. All right. Have a great rest of your day. I will see you all at the premiere of the Calls Without Commentary. And then obviously for commentary after the fact. You guys have a great rest of your day. And I will talk to you all later. Bye.